Thanks, Pascal.
Okay. Awesome. Thank you, Ryan. And thank you, everyone, for coming out to our Academy space today. As Ryan said, I'm one of the postdocs at the Western Academy for Advanced Research this year. And over the next half hour or so, I'm going to be talking about my latest main research project, which was my dissertation that I recently defended here at Western in comparative literature. But since this workshop today is also supposed to help at least the core members of our Academy theme this year to get to know me a little bit better, let me actually first lose a few words on how I got here. So ever since I've been doing research, I've been interested in intrastate conflict and topics of transitional justice, even though that's perhaps not how I would have necessarily labeled it. So while I was pursuing an undergrad in Hispanic studies, for example, I worked on Spanish literature and film, dealing with the Spanish Civil War and the Spanish transition to democracy, with special focus on issues of historical memory. And during my graduate studies in comparative literatures and arts, I felt that I still had quite a bit to say about this, so I dedicated my research to Spanish film and graphic novel, dealing with questions of intergenerational trauma related to the legacy of the Spanish Civil War. Then, with all of this in tow, I arrived here at Western to pursue my PhD in comparative literature. And I also soon found myself in a course offered at the Center for Transitional Justice and Post-Conflict Reconstruction, which opened my eyes to a whole new world of scholarship and new ways in which I could inform my own work in literary studies. So in today's workshop, I'm going to be talking about my recent dissertation that was concerned with fictional representations of the legal prosecution of Third Reich injustice in West Germany. Okay. When we talk about the legal prosecution of Third Reich injustice, we may immediately think of proceedings such as the Allied-run Nuremberg trials in 1945, or the trial against Adolf Eichmann in Jerusalem in 1961. But we may also think of the Frankfurt Auschwitz trial in West Germany that took place between 1963 and 65, with 22 former guards of the Auschwitz concentration camp on the bench and more than 360 witnesses heard in court. And especially in Germany today, the legal prosecution of Nazi crimes is tied to the name of Fritz Bauer, who served as director of public prosecutions in the 1950s and 60s. Bauer actually played a key role in initiating the Frankfurt Auschwitz trial, but he also provided essential information that eventually led to the arrest of Adolf Eichmann. And as I will show you, Fritz Bauer also plays a big role in many of the fictional narratives I'll be talking about today. If you're not already familiar with the topic, you may now ask yourself, what makes the legal prosecution of Nazi injustice in West Germany in the 50s and 60s such an intriguing topic to study? Aren't these just ordinary criminal cases where someone did something wrong and then gets punished for it in court? Well, as the fictional works I'm going to talk about today emphasize, the legal prosecution of Nazi criminals and Third Reich injustice in the 50s and 60s, in fact, pose difficult questions. What exactly constitutes criminal wrongdoing in the eye of the law? And why can't every human rights violation be prosecuted? What exactly does the law require to determine if wrongdoing did occur and to assign criminal guilt? In other words, how does retributive justice work, and why is it so difficult to bring systematic human rights violations in front of a court, establish the truth about them, and hold perpetrators criminally accountable? Precisely these and other related questions lie at the core of the fictional works I'm going to be taking a closer look in my talk today. So these are the fictional works I examined for my study. We have, first of all, Giulio Ricciarelli's Im Labyrinth des Schweigens, film from 2014, which focuses primarily on the investigations that eventually led to the Frankfurt Auschwitz trial. We have Annette Hesse's novel Deutsches Haus, or The German House, which portrays the main proceedings of the Frankfurt Auschwitz trial itself. We have a play by Gerold Theobald, which tells the story of Fritz Bauer's role in the Frankfurt Auschwitz trial, but also of his investigations against Eichmann and Hans Globke, who was chief of staff of the West German Chancellery at the time, who had his own past as a Nazi lawyer. Then we have two films by Lars Kraume and Stefan Wagner, which both primarily aim their attention at Fritz Bauer's contribution to the apprehension of Eichmann in Argentina and his investigation against Globke. And then finally, We have Ursula Krechel's novel Landgericht, or District Court, which contains the fictionalized biography of Robert Michaelis, a Jewish German judge who returned to the Federal Republic from exile and struggled to regain his position in the West German judiciary. And then finally, we have a play by Ruth Barnett, who actually is the daughter of the real-life Robert Michaelis, and her play stages another version of her father's life as a judge in the young Federal Republic. Okay, before getting into the findings of my study, let me briefly address the relationship between the study of fictional material and the study of transitional justice. So as scholars in the field keep stressing, there are intriguing synergies between fictional writing and the study of transitional justice. However, there's an important distinction to be made. The archetypal relationship between fictional writing and transitional justice, to which many scholars refer to in this context, applies first and foremost to fictional works that portray a very period of injustice, violence, and oppression that precedes political transition. The fictional works I have selected for my study, however, take a different perspective. Rather than focusing primarily on the atrocities themselves, they shed light specifically on their prosecution during and after the phase of transition. And it's precisely this distinction that leads Ward, and I put the quote up here, to understand especially the three films I looked at in my study as responses to a shift from memory to remembrance as the primary mode of cultural engagement with German national past. In other words, the fictional works I've examined can be understood as attempts, as Demiragic and Hodžić would say, to, quote, illuminate the often neglected questions of the here and now of a transition. Or as Dubé would say, the fictional narratives can be considered to, quote, bear witness to these moments' complicated nature. So with all this in mind, I'm going to show in my talk today how the fictional works I examined engage critically with commonly accepted notions of the scope, principles, and objectives of legal prosecution, how those works problematize simplistic understandings of legal proceedings and question the suitability of investigations and trials to address systematic human rights violations, how in response to the limitations they uncover, the fictional works envision a notion of justice that extends beyond a purely retributive dimension, and finally, how these fictional narratives can offer meaningful perspectives on the complexities of transitional justice, thus enriching discourse that is customarily the domain of legal, historical, and political scholarship. Okay, in terms of structure, I arranged my study in a way that reflects the typical path a given criminal case takes from accusation to verdict, which allowed my study to parallel the general trajectory of the fictional plots, but also to emphasize how the limitations of the portrayed legal approaches accumulate along that path. So accordingly, the first section of my study was dedicated to the fictional works' portrayal of prosecutorial attempts to bring potential cases to court via preliminary investigations. As I found out in my study, the fictional works present even this very first step as a considerable challenge. In one of the films, for instance, the portrayed investigations are set off by the fortuitous discovery of documents that contain internal SS correspondence concerning the shooting of inmates at Auschwitz in the early 1940s. And even though those lists contain the names of both the inmates that were executed and the SS guards involved in the shootings, the film emphasizes that this really is only a very first step that may merely present new leads to follow, and that all of the actual investigative efforts lays ahead still for the prosecutors. The film here highlights a tension between idealist aspirations for retributive justice and more pragmatic considerations regarding the feasibility of legal prosecution in these cases. And it's precisely this tension that drives all the fictional works I looked at, and this film here by Ricciarelli in particular. The fictions also attest to considerable institutional resistance to the portrayed investigative efforts that they ascribe to both failed lustration efforts in the West German public sector and complex political considerations. With regard to the former, the fictional works speak to a typical problem any new regime has to face during a phase of transition, namely the question of how to staff the government and other public institutions. In the case of the West German transition, as part of a larger strategy that was labeled democratization through integration, large numbers of previous administrators retained their positions under the new government. And as the fictional narratives point out, for the prosecution of Nazi crimes, that turned out to be a problem. The fictional plots are full of instances in which members and supporters of the old regime abuse powerful positions with the aim of spoiling the investigative efforts and thus protecting themselves and their old comrades. Another facet of the portrayed institutional unwillingness to support the legal prosecution of Nazi atrocities is related to complex political considerations. In the fictional works, the complexity of this political context becomes most apparent in the investigation against State Secretary Globke, who I mentioned before, Chancellor Adenauer's chief of staff, and his connection to the investigation against Adolf Eichmann in Jerusalem. So there was a concern at the time in the West German government that at his trial in Jerusalem, Eichmann would drop the names of other former high-ranking Nazi administrators, including Globke, which in turn would have reflected poorly on the West German government, which in turn would have weakened the West in the context of the Cold War. And especially the films by Wagner and Kraume refer to this concern in order to reveal how these kinds of political considerations can have a massive impact on the success of investigative efforts. So to sum up this first section of my study, the fiction works dedicate much of their attention to the various challenges the prosecution of Third Reich crimes is facing just in order to pursue preliminary investigations. In doing so, the fictional works emphasize that the structures and procedures outlined by the law, here the West German Code of Criminal Procedure, cannot bring about justice by themselves. It is not sufficient that the law provide the opportunity to bring accusations to court and to define a legal pathway to follow for the prosecution. Rather, the success of criminal investigations also depends on the availability of strong evidence and the support of the institutions that are supposed to enforce the law to further pursue that evidence. Now, once a case is set in motion, evidence assumes a perhaps even greater importance, for its persuasiveness ultimately determines whether or not a court is able to establish the truth about the events in question and how guilt and punishment are determined correspondingly. Here, the fictional works raise significant concerns, especially about the reliability of testimonial evidence. In particular, they contain numerous instances in which the observations made by witnesses fail due to a lack of specificity to meet the court's requirements for reliable evidence. The fictional works in this context all suggest the same notion. Observing means not merely observing the criminal act itself, but also registering a frame of reference, date, time, location, names of victims and perpetrators, etc., that is technically independent from the act itself, but essential for its identification after the fact. As the fictional works underline, in order to establish truth, the law requires accounts of events in the past to be pressed into shapes that it is able to understand and process further. The fictional works here also emphasize the consideration that especially the kinds of human rights violations that transitional justice is typically concerned with are often committed under conditions that prevent witnesses from observing the events in question with the level of accuracy that the law requires in order to establish truth about the past. And as I think the examples I've pulled up here, the fictional works drive home that notion particularly forcefully. Fictional works also examine the use of documentary evidence as both a potential remedy for the limitations identified in the context of witness testimony, but also as a category of evidence that comes with its very own limitations in the context of prosecuting Third Reich crimes. Several of the fictional works I studied include plot lines in which it is the introduction of documentary evidence that ultimately leads to the arrest of suspects that wouldn't have been possible based on witness testimony alone. Crucially, however, the narrative design of most of those episodes elevates the impact that the introduction of documentary evidence is able to make on a given case to a level that exceeds the assessment made by legal and historical scholars of the actual trials. So especially in the films, it's often a single photograph or a single signature in a document that is presented as the decisive piece of evidence in the case, when in reality, documentary evidence in these kinds of cases would only serve as circumstantial evidence and only as one part of a much larger puzzle that had to be pieced together in order to charge suspects. And this discrepancy can be linked to a general strategy of narrative condensation that the fictional works necessarily pursue in order to fit large amounts of information into a few hundred pages or 2 hours of film. But it can also be explained with the need to construct plot lines that engage the audience. So actually, in each of the episodes I looked at here, the introduction of documentary evidence is used as a narrative device to release tension that is previously built up by portraying the prosecution's inability to solve the case based on witness testimony alone. In the context of documentary evidence, studies of the legal prosecution of Nazi atrocities have also recognized challenges of a more logistical nature. On one hand, scholars here point to the infamous Nazi mania for record keeping. On the other hand, however, it's also emphasized that by the late 1950s and early 60s, even though an abundance of material was in theory available, only a fraction had already been processed in a way that allowed it to be actually used in court. So the scholarship here points to a stark contrast between the general availability of documentary material and the limited practical accessibility of the information contained in it, a concern that's also voiced in almost all the fictional works I examined for my study. And all the fictional works here come to the same conclusion, namely that the scope of the investigated crimes, and in particular the considerable amount of corresponding documentary evidence, provide logistical challenges that push the criminal justice system beyond the limits of what it's designed for. So to sum up this second section of my study, despite the large amount of testimonial and documentary evidence available, the fictional works portray the prosecutorial burden to produce evidence capable of meeting the applicable standard of proof as particularly high. Crucially, this struggle is presented not as a fault or shortcoming on the part of the prosecution, but in terms of the incompatibility of the ordinary design of the legal truth-finding process with the extraordinary circumstances of the portrayed atrocities and investigations. So in the first two sections of my study, my discussion of the fictional works has focused primarily on the portrayal of the prosecution's struggle to successfully establish the facts about the events in question. However, as the fictional works all emphasize, while the gathering of evidence that can hold up in court is crucial to prove that the defendants indeed performed the actions of which they stand accused, the question of whether a court will actually convict them of having committed a crime is a different one entirely. In other words, the question of whether or not a defendant is found criminally guilty depends not only on the gathered evidence itself, but also on its interpretation. And the challenges the prosecution is facing here once again stem from the extraordinary nature of the crimes in question. The fictional works emphasize that, especially in the context of systematic state-ordered human rights violations, the interpretation of evidence goes beyond persuading the court's opinion in a given individual case. Rather, to interpret the evidence brought before the court means to suggest answers to complex jurisprudential questions that shape the understanding of the committed atrocities as a whole. The fictional works portray this final step from proof to verdict not as a mere formality, but rather as a hazardous path that stretches the capability of legal prosecution to answer fundamental questions of criminal guilt convincingly. As the fictions emphasize, holding the perpetrators of Third Reich atrocities legally accountable is indeed an exercise in storytelling. And a few instances in the fictional works, and I've put one here, showcase just how wide the range of interpretation of evidence can be stretched in theory. So the one quote I pulled up here is from a defense lawyer, one of the films, and it's a line of argumentation that was actually used by the defense at the real Frankfurt Auschwitz trial. In the scholarship, it's also referred to as the Schindler's List defense. So importantly, the fictional works don't grant this brazen form of interpreting the evidence a whole lot of persuasiveness. But by including examples such as this one here, they underline the potential and need for the interpretation of evidence if criminal guilt is to be established. Even more intriguing are instances in the fictional works in which the distinction between guilt and innocence is much more nuanced and ambiguous. For example, in the fictional works, the interpretation of evidence is especially relevant in the context of determining the individual legal responsibility of defendants for the committed crimes. Here, the narratives pose a number of difficult questions. For instance, what degree of responsibility for the death of millions lies with the camp guards who selected prisoners upon their arrival? How about the guards who were handling the chemicals? And what about the administrators organizing the killing without ever stepping foot into a camp? In short, where's the line between criminal culpability and innocence to be drawn? As the fictional works emphasize, finding answers to these questions depends heavily on the way in which the collected evidence is interpreted and in which the story about the events in question is told. In particular, the fictional works here engage with two legal doctrines, which is first of all the law of superior responsibility, which stipulates that responsibility and thus criminal culpability moves along a chain of command. So considered from this perspective, a higher ranking defendant can be expected to have carried more of the responsibility than a defendant at the bottom of the chain of command, which is exactly what leads the prosecution in Kraume's film to focus its efforts on Adolf Eichmann as a central figure. That's the first quote I have here. As the Bauer figure in Ricciarelli's film points out, however, and that's that second snippet, focusing merely on the highest step in the chain of command represents not a solution to, but rather an avoiding of the complex question of where exactly the line between criminal responsibility and innocence needs to be drawn. It makes it all too easy for lower-ranking defendants to simply shift blame upward on the chain of command, thus evading individual responsibility. The Bauer figure in Ricciarelli's film thus advocates to pursue investigations based on a second legal doctrine, namely the law of enterprise participation, which stipulates that everyone who's involved to some degree is considered equal part of a joint criminal enterprise and thus criminally culpable. The advantages here are obvious. Blame can no longer be shifted, and it's also a way to differentiate or to do away with differentiating between different levels of guilt. However, this approach comes with its own problems. As all of the fictional works emphasize, it's not realistic to actually prosecute every single person that was somehow involved in the crimes of the Third Reich, which means that prosecutions conducted based on the doctrine of enterprise participation would be highly selective. As one of the prosecutors in Ricciarelli's film points out, and that's that final snippet I have here, such selectivity jeopardizes the very notion of individual accountability and of fair prosecution. So to sum up this third section of my study, the fictional works insist that reliable evidence alone does not suffice to hold the perpetrators of mass atrocity criminally accountable. Rather, they emphasize the fundamental importance of narrative strategies to implot factual truth about the events in question as meaningful stories that can then be translated into legal verdicts. By portraying the final step from proof to verdict as a section on the path toward retributive justice that arguably raises more questions than it can answer, the fictions expose yet another layer of the law's limited ability to address systematic human rights violations. In the simplest of terms, the fictional works here portray the court's task of reaching verdicts that not only satisfy the law, but also appear just in the eyes of the involved parties as a particularly difficult one. Sooner or later, the fictional plots in all of the works I examined reach a point where, due to the limitations of the law, retributive justice is ultimately considered as unattainable. In response to the limitations of the law they uncover, the fictional works instead postulate notions of justice that extend beyond its purely retributive dimension. In particular, they assign to the portrayed legal proceedings an educational dimension that contributes directly to the endeavor of post-conflict truth-telling. And in doing so, they echo an understanding that existed already at the time of the actual Frankfurt Auschwitz trial, and that's been emphasized in subsequent historical and legal scholarship. Already before the trial, for instance, Fritz Bauer had insisted that legal prosecution in cases of Third Reich atrocities should not be about revenge or retribution, but about making the truth about the committed crimes known and thus providing all Germans with the opportunity to pass judgment upon themselves. I found that the fictional works reflect this stance most prominently in statements made by the respective fictional Bauer figures. By emphasizing the importance of both truth-finding and truth-telling, the fictional works here advocate what Michel Parlevliet has described as a dual understanding of truth that is common in contexts of dealing with past human rights violations and entails, quote, not only knowledge, but also acknowledgement, the determination of facts about the past, and a full public and official acknowledgement thereof. So in essence, the trial, as they are envisioned in the fictional works at this point, does have intentions similar to those of truth commissions. And in particular, the fictional works pick up Fritz Bauer's hope at the time that the Germans could learn two valuable lessons from the investigations and trials. In the first lesson, Germans were supposed to come to terms with the realization that the perpetrators of the Third Reich were not brutal monsters, but ordinary people that in many cases integrated successfully into the new democratic society of the Federal Republic. Here, both the real Fritz Bauer back then and the fictional works now draw on the notion of the banality of evil, the term famously coined by Hannah Arendt in her report on the trial against Adolf Eichmann in Jerusalem. For example, there are many instances in the fictional works in which the people involved in investigations can hardly believe just how ordinary the defendants appeared to them. And then in a second related lesson, the investigations and trials in the fictional works are supposed to bring Germans to acknowledge that a majority of the population had failed in their duty to say no to National Socialism and its atrocities, and thus carried at least a moral responsibility for the committed crimes, even when there was no question of any actual involvement in a particular crime. Ultimately, the fictional works, for the most part, portray this endeavor of educating the public through legal prosecution as successful. They all convey the understanding that truth-telling in the context of legal prosecution is able to make important contributions to the struggle for transitional justice and reconciliation. Not just that, some of them even frame the portrayed prosecutions, especially the Frankfurt Auschwitz trial, as a turning point in German post-war history. There are indeed many historians who would agree with that label, even though more accurately, it was perhaps a starting point of a larger process that would stretch the following decades. So the assessment that the fictional works make here is especially interesting if one considers the temporal gap between the time at which the works were published. They were all published within the past 10 to 15 years, and the time at which their fictional plots are set in the 50s and 60s. And all of the fictional plots actually end before or shortly after the conclusion of the Frankfurt Auschwitz trial in 65. Which means that anything the works have to say about the success of legal prosecution as a means of educating the public in the long term is necessarily pushed into a future that exceeds the fictional plots. And some of the fictional works attempt to address this future in the form of epilogues. And I think the first two snippets I pulled here, those are both, it's just text that's running before the credits at the end of those films. Now, of course, by concluding their respective plots just after the trials in Frankfurt and Jerusalem, and thus only at the very beginning of a much longer period of reconciliation efforts in West Germany, the fictional works deprive themselves of the opportunity to convey their claims in the context of truth and reconciliation more decisively. At the very least, one can conclude that the works in this context make a poetic leap that, in the eyes of Ruti Teitel, and that's the quote I put up here, is typical in transitional storytelling. So they seem to answer the question in a way that says it was the trials first that set up the reconciliation process, but since they're not actually engaging with the decades that followed those trials, it's a bit of a, well, we know from today's perspective how it went, but from the perspective of the fictional plots, it's a foregone conclusion. So even though the fictions in this regard clearly emphasize the importance of establishing the truth about the past in order to move toward future reconciliation, they are ultimately unable to illuminate persuasively the complex path toward reconciliation that must be walked after truth has been told in court. Okay, in conclusion, and as I hope my talk has been able to demonstrate, the fictional works I examined for my study provide their respective audiences with an opportunity to confront anew a period in German post-war history that has proven crucial in shaping the path that the Federal Republic has taken since. Crucially, even though the fictional works focused almost exclusively on legal prosecution in West Germany, their engagement with fundamental questions of transitional justice goes beyond the West German context, precisely because they ascribe the limitations they uncover to situations and conditions that are typical of transitional environments. Arguably, their most valuable contribution in this regard is their combining insight from the various academic disciplines involved in the study of transitional justice and making that insight intelligible to a larger audience in a way that academic scholarship typically cannot. Importantly, what the fictional narratives provide in this context cannot be expected to replace the historical, legal, and political scholarship that I've consulted throughout my examination of them. In their condensed fictional representations of the events they portray, the works I've examined in my study do not promote the kind of comprehensive understanding of complex transitional justice issues that can only emerge from rigorous scholarship. Yet, they allow especially non-expert audiences to develop a sensitivity for the complexity and difficulty of these issues. Thus, and this is the thought I'd like to conclude on, making a crucial contribution to the Transitional Justice Project by bridging the gap between transitional justice as a field of interdisciplinary academic inquiry and transitional justice as a sphere of practice.